Good morning, everyone. My name is Alex Barthet. I am a board-certified construction lawyer here in South Florida. And today we're going to talk about something that we run into occasionally. Many clients don't understand what it means. So we're going to demystify what bonding off my lien means. And I'll tell you why you should be excited if someone ever tells you that. So let's go ahead and get started. So our agenda is as follows. First, we're going to talk about what a lien is and how it works, because you'll need to understand that to understand why bonding a lien off works and the intent of the statute behind bonding off your lien. We'll describe what it actually means and how it's done. Once I describe it to you, we'll talk about what it actually means for you and how you get paid. All right, so let's go ahead and get started. So let's start with what is a lien and how does it work. As many of you may know, a mechanic's lien in Florida secures payment for materials that are furnished to the job and services that are rendered to the project, including, by the way, rental equipment. As long as the proper notices are filed, and we're going to talk about what those notices are in a minute, a lien encumbers, meaning it locks up a portion of the real property or a lease equal to the value of the improvements on the property that remain unpaid. And then once the lien is properly recorded through a legal process called foreclosure, the property can be sold to satisfy the lien, subject to any equity in the property. So that means that if you have a lien on a piece of property for, let's just say, $100,000, you will encumber, effectively hold $100,000 worth of that property. Now, the problem is, and this is where bonding off gets, why bonding off is important, is that lien may prevent people from doing things on the property like refinancing or selling. Now, before we get into what bonding off really means, let's go through briefly the requirements in order to properly secure your rights on the lien. So first, within 45 days, no later than 45 days from your first work or delivery of materials to the property, a notice to owner needs to be served on the owner and possibly the contractor and other parties listed in the notice of commencement. 45 days is the outside time frame. If you have a contract directly with the owner, then you don't need to send this notice to owner, but it usually is still a good idea to do it. So that's the first notice that's required. Next, no later than 90 days from the last work or last furnishing of materials on the job, you need to record your claim of lien. It's a document that's prepared, signed under oath, and brought to the clerk's office where the property is located and recorded. That is the encumbrance on the property. It's the claim of lien. A copy of that claim of lien needs to be served within 15 days of the recording date on all interested parties. Now, if you use a service like Sunray, they take care of all of the items on the screen right there, the 45-day notice, the 90-day notice, as well as serving it on all interested parties. Now, if you are in privity with the owner, meaning you have a contract with the owner, then you need to serve what's called a contractor's final affidavit 5 days before you file suit to foreclose. Ideally, you should do it sooner, even as early as when you record your claim of lien. And then finally, within 1 year of the recording date of the claim of lien, you need to file this foreclosure lawsuit. So these are the rough steps that you have to follow in order to secure your right to have a lien on a piece of property. All of these rules, by the way, have lots of exceptions. It's a very complicated area of the law, but this is a thumbnail sketch of what you need to do in order to protect your rights. So let's get into the meat of it here. What does bonding off my lien really mean? Well, as I told you, this lien that you may have put on a piece of property is now encumbering it. It is preventing the owner from refinancing, from selling the property. There may be a mortgage on the property, and as a result of your lien, they may be in default under their mortgage. So there are many reasons why your lien needs to come off of the property. So we talked about a few, but if there's a loan, the bank may require that the lien come off. If this is a lease, the landlord may require that the tenant bond off any liens on the property. Prime contracts and subcontracts typically contain provisions that say if anyone underneath the contracting party, so maybe a sub or a sub-sub, allows a lien to be put on the property, they have an obligation to remove it or bond it off. So there's lots of reasons why a lien on a piece of property may need to come off. If any of those happen and a party determines that the lien is a problem and needs to come off, then that's when they need to look at bonding off the lien. Now, this is different than when a project has a payment and performance bond issued by the contractor at the outset of the job. Many jobs, large private jobs, and almost all public jobs are bonded by the contractor with what's called a payment and performance bond. When those jobs have that type of bond at the outset, then your recourse is not a lien on the property, but it's a notice of non-payment on the payment bond. How do you know if a job has a bond on it to begin with? A reference to that bond would be included in the notice of commencement, which is the document that's recorded by the owner at the outset of the project. When Sunray prepares the notices, they check to make sure if the job is bonded or not, and then they send the proper notice. But if you want to know, you can pull the public record in the county where the project is located, doing a search by the name of the owner, and it will pull up the notice of commencement, and you can look at the notice of commencement and it will tell you if there is a surety on the job. A copy of that bond should also be attached to the notice of commencement, which is at the job site. So you can go to the job site and it's supposed to be posted there, and you should be able to see if the job is bonded. Again, if the job has a payment and performance bond at the outset, then that's where the claim is. So you don't have a lien on the property, you have a claim on that payment bond. But assuming that isn't what is applicable here, but you have a lien on the property and someone needs to remove it, they need to get what's called a transfer bond to bond it off. So how does that work? There's a complex formula in the lien statute that talks about how much money someone needs to come up with to remove your lien from the property. In round numbers, it's about 150% of the lien amount. So if you record a lien for $100,000, someone is going to have to post a bond for about $150,000 in order to get that lien off the property. This is not subject to negotiation. It's a strict formula that's followed by the clerk. The reason that there's this 50% extra is in the statute, it's intended to cover incurred legal fees, costs, and interest associated with the dispute that may follow from the bonding off of the lien. Now, obviously, if the lien is for $10,000, that 50% extra is very small, but if it's $1 million, then it's much, much larger. So keep that in mind. Now, how does someone bond off the lien? They have two ways to do it. They can use cash, and they take that cash in the form of a check, cashier's check, to the clerk's office where the property is located, in the county where the property is located, and the clerk will take that amount, issue what's called a certificate of transfer, and the clerk will hold the money. And then they will record that certificate of transfer in the public record so everyone is on notice that there was a lien and then there was a transfer bond. As well, a copy of that transfer bond will get mailed, sorry, not the transfer bond, the certificate of transfer will get mailed to the lienor, notifying them that their lien has now been transferred to a bond. Sometimes people don't want to post cash, so they want to get what's called a transfer bond. A transfer bond is a bond issued by a surety, an insurance company. So you have to go to an agent, a surety agent, to get that bond. And the way that bond works is that a surety company will issue a bond for the same amount of money, so the formula remains the same, and they will issue a bond, and then that bond is brought to the clerk's office, and the clerk will, instead of taking the cash, will take that transfer bond and issue a certificate of transfer. So the process from the clerk's perspective and the lienor's perspective is the same. The difference is that either the security that's backing that transfer is either cash held by the clerk or an insurance product, a transfer bond, held by a surety. Now, if someone goes to a surety to get a transfer bond, typically they will need to post 100% cash collateral. It depends on what the surety wants, but most sureties for transfer bonds want 100% cash collateral, meaning that instead of giving the money to the clerk, they have to give the money to the surety to hold, and then they pay a premium, typically between 1 and 3% of the amount transferred. That's the bond premium that the surety gets to keep. And then they'll also sign what's called an indemnity agreement. So there's a lot more paperwork associated with getting a transfer bond, but for various reasons, some people prefer transfer bonds over cash and vice versa. So if someone tells you that they bonded off your lien, what should you do? You should celebrate, because now you have a security on against your lien that is not subject to other encumbrances on the property. So if you remember, I told you that your lien ties up the property, and any equity in the property can be used to pay off your lien. But let's take an example of a property that's worth $1 million and you're owed $100,000, but there's a $900,000 mortgage on the property. The property is not sold in the foreclosure process in the free market. It's sold at a foreclosure sale. And foreclosure sales typically have a significantly depressed market value or sale value. So you don't get free market value for the property. You get fire sale prices for the property. So that $1 million property may only go for $700,000, but I told you there's a $900,000 mortgage. So it's not likely that you're going to recover anything in my example. We saw a lot of this when the recession happened. People recorded liens, but that lien was behind a mortgage. The mortgage started the foreclosure process. That lien was worthless. So if someone bonds off your lien, now you don't have to worry about the status of the title of the property, because 100%, actually 150%, give or take, of your lien is now backed by either an insurance product designated just for you or cash held by the clerk. However, while you're celebrating, just know that you need to get ready for a fight. Someone obviously doesn't want to pay you if they've taken the effort to bond off the lien. Maybe they think your lien is defective. Maybe they have issues with the work you performed. Maybe they believe it was late. Whatever the reason, it obviously would have been faster and potentially cheaper to write you a check or negotiate a settlement with you if you were if they were willing to do it, rather than go through the time, effort, and expense associated with bonding it off. So what we typically see is that someone is bonding off your lien because they don't want to pay it. So you have to get ready to fight. And as a result, when our clients receive a certificate of transfer, our advice typically is to commence the foreclosure process immediately. And the foreclosure process is the same, except instead of foreclosing on the property, we're foreclosing on the lien transfer bond or the lien transfer certificate if there's cash. So everything is the same. The obligation to prove up the case is identical. The difference is that if there's a recovery, it comes from the bond. So when our clients get these certificates of transfer, we counsel them to start the foreclosure process right away, because if obviously someone wanted to pay you, they would have. So this is a clear indication that they don't. Remember, you only have 1 year from the recording date of the claim of lien to initiate your lawsuit on the transfer bond. So it does not extend the time. We had a client come to us, and it was about 8 months after they recorded the lien that they bonded it off, and then they waited another 6 months after that to come and see us with the certificate of transfer, and they said, okay, we'd like to get started. Unfortunately, it was too late because it was more than a year after they recorded the claim of lien. They thought they had a year from the certificate of transfer. That is not the case. You have 1 year from the recording date of the claim of lien in order to initiate the foreclosure process, even if your lien is transferred to a bond. And always remember that this 1 year can be shortened. There are procedural mechanisms that exist in the lien statute that allow someone to reduce that 1 year down to either 60 days and sometimes even down to 20 days in order for you to start the foreclosure process. So don't delay. If you get any notices that allude to shortening the time or a certificate of transfer, you should move swiftly to protect yourself. Okay. Thanks, everybody. Goodbye.